provide some introduction to the topic. And then Allison Eklund, an attorney who we've been working with over the last 6 or 7 years, is also here to talk about some of the tools that landowners might be using for land transfer. And so the presentation that I'm going to give, and I'll talk for about 20 minutes or so, 25 minutes, it's based on a presentation by Paul Catanzaro and Adam Downing, both Massachusetts and Virginia. They've also been working on this a while. And so the outline that we'll go through for the entire hour is I'm going to talk a little bit about why we feel this is important, some of the key messages that should be involved with any land transfer discussion with landowners. Talk about some definitions, particularly of conservation-based succession planning. And then I'll talk about communicating the message. Allison will talk about land ownership and tools for planning, and then I'll conclude a little bit with some resources at the end of my presentation. Okay, I want to talk just a little bit about the National Woodland Owner Survey and some preliminary results that came out in 2013. The age groups of landowners and who owns what land and how much land they own. At about 55 years, 55 to 75 years is where we find most of the land of age. Most people are 55 to 75 who own land, and most of the land area is also owned by people of that age. And so this creates kind of a potential problem as people age and pass the land along. If it's not passed to the next generation, or if there aren't other tools in place to keep the land intact, what we know is it's likely to become fragmented or broken up and sold in smaller parcels. And so what's at stake for the families that we work with as we're working with the landowner? And many of them that I've talked to in Minnesota want to keep their land in the family. And so it has to do with family dynamics, and it has to do with passing that land ethic to the next generation as well as the land. What's at stake? It's the families and that family dynamic. The other things that are at stake are, we know that forest land, when it's in larger tracts, can be managed for timber. There's more, there's wildlife benefits. We don't have that fragmentation. We can have larger corridors and larger areas for wildlife. And so as we think about those things and some of the reasons we want to keep this land intact, we can think about conservation-based estate or succession planning. And this is planning to keep some or all of the land undeveloped. And we already know that many landowners know that they have an option to subdivide, but fewer landowners know their options for how to keep the land in the family or how to keep the land intact as it moves on to the next generation or to the next owner. And so the primary goal of conservation-based estate planning is to keep as much undeveloped land or as much working forest land intact as possible. We want to reduce conversion and parcelization of land. And so this is our first poll. And what I'd like you to do is just let me know if you're primarily a consulting forester, an extension forester. This is to give us here in this room a little bit of an idea of who the audience is. And so we'll give you a few minutes to go ahead and respond to the poll, and then I'll get that information directly from Noah.
Okay, we have some answers coming in. I'll give it a few more seconds here. All right. It looks like we've got 6 chiming in as consulting forester, another 4 as the third choice of municipal, state, or federal forester, and then 1 each for the last 3, 5, 6, and 7.
Okay, good. And so that's great. So we've got majority are consulting foresters and some municipal, state, or federal foresters, and then 1 each of the last 3. Land trust, is that right, Noah? 1 there? Or one in natural resource plan or landowner and other?
Correct.
Yeah, okay. And for everyone, I'm confident that you'll learn quite a bit in this presentation. For the landowner there's some information at the end that you may want to attend a full 6-hour workshop on this topic that's coming up in October, and I'll provide a date for that at the end of my presentation. So for our next poll, it's for those foresters. I'm interested if you've spoken to landowners about the future ownership of their land. And if you have, how often, and if you haven't, just go ahead and click rarely.
And while they're filling that out, I'm getting some feedback from Cloquet that we had another 2 under other.
Okay.
For the previous question.
Great.
Okay, and here comes the second poll. It should be on your screen at this point, and then once we get some answers, I'll start broadcasting the results. Okay, looks like we've got a few coming in, and I'll give it another 30 seconds here. Looks like a pretty even spread. The winner is 3 occasionally,
okay,
with 1 or 2 in the rest of the categories. So 1 is chiming in as never, 2 and rarely, 2 and often, and 2 and very often.
okay.
And then a Cloquet is coming in through text by saying 1 occasionally and 2 rarely.
Yeah, and if you want to chat in, on maybe, what prompts you to discuss this with landowners, or what causes you to be hesitant, if you chat that in, Noah will go ahead and relate that to me, and I think that will be valuable information for everybody as well.
Looks like a couple more under occasionally.
Okay.
But pretty even spread.
Yeah. We'll talk a little bit here in the next few slides about some questions that you can use to engage landowners in that type of conversation. And so what we know from teaching land transfer with landowners is that land transfer involves, successful land transfer involves communication among the family. We know that if landowners just have a will, a trust, or other legal tool to transfer land on to the next generation, and there has been no communication about that with the family, very often there's one family member who really may not want to stay in it or can't stay in that relationship, and it causes problems for keeping the land in the family or keeping the land intact. One of the things we found out important, the other thing that we found out that is important about teaching this is the continuity of the land ethic, and how do we pass that along. So I'll mention now just a few of the ways. It has to do with the stewardship plan. It has to do with engaging family members in activities on the land and keeping them active in and knowing how the land is being managed. And then the final thing with successful transfer are the legal and financial tools. So in summary here, or to emphasize, conservation-based estate planning, it's a process. It includes both documents and tools as well as activities. Documents can be the stewardship plan, tools can be a will, a trust, a limited liability company, and activities might be those fun times that you have with family or that families have on their land. And what we know about land is land is likely to be the landowner's most valuable asset, but it's not like other assets. It has personal value. And so it's trying to balance those personal values and the financial values that the land has. And one of the tools that we use with landowners is an heirloom scale. This is one of the entry points of starting a conversation with landowners and with their families. And we provide them this tool to talk about whether the land is one of their most precious financial assets or if it's one of their most precious heirlooms to be protected at all costs. And what we find is that landowners will answer this depending on what their needs are at the time. It will change over time, and that's okay. The important thing with this tool is that it provides the landowner, the family, with a way to start discussing the land and how people feel about it. So land is a flexible asset. It does tend to lend itself to some creative solutions for balancing that difference between financial and personal values. And there's no one right answer for working with landowners or for the landowners. You want to discuss the wishes for land with the family. They can formalize their wishes in a will or a trust. One of the ways that a forestry professional can work with the landowner is to review the ownership type. And as a consultant, you probably have already looked up what type of ownership it's in. It's on the title. And I think Allison will be talking a little bit more about ownership type. And landowners also have, you may have talked to them about conservation easements, donations, or sales. And so from the landowner's perspective, some of the challenges are the expense of trying to keep it in the family, or expenses that they've got to meet now, so they may need some money from the land. But the biggest thing that we found is they have a hard time connecting with professionals, both attorneys and with foresters and other people who can help them start the process of land transfer. So what we do know is that natural resource professionals play a really important role. Kent Zaro from Maryland has found that nearly a third of the landowners seeking advice ask their forester as a starting point. And so as a forester, you want to be patient and ready. Be ready to ask questions and to provide some advice. Landowners' decisions, as they are with most forestry topics, are infrequent. Succession planning is complex, and but there are many opportunities to help. And so the good news is that we don't have to, as foresters, know a lot about succession planning. We know about forestry. The bad news is it may cause us to get out of our comfort zones. People, families, it's kind of a messy business sometimes, but that's okay. We can instigate the conversations, and the next few slides are how do I broach the topic. Most landowners aren't going to bite, like this little dog sign, I won't bite. And so we can ask landowners questions. What are your thoughts for the future of this property? And I think about this, as I'm working with a landowner and talking about the trees, we're often thinking 50 or 100 or 150 years from now and the future of their forest. And so who will be owning that forest 50 or 100 or 150 years from now? Find out if the children are interested or if they have children that might be interested. Ask what they want to happen or how do they envision the property and who might own it in 100 or 200 years. And what you might hear, and this is based on some of the things I've heard and some of the things that Paul Kent and Zaro has heard, is some landowners just say, I have a will and that will take care of my stuff. And the important things about wills is they transfer property, not necessarily the goals or the management of that property to the next generation. A lot of folks think maybe they're only 60. It's too young to begin planning. And what we know about that is if they begin planning early, it gives them lots of time to begin planning for the differences in family members and the different interests of family members. So starting now provides time for that shared planning and the transfer of the values. Or it's too expensive. And what I'm finding out about land transfer is, yes, there are some costs, but it's not nearly as expensive, I think, as many landowners might think. And it provides the opportunity to pass on the value. So I think one of the important things that we as foresters can do is encourage landowners to engage family members in management activities and planning, getting the kids out, planting trees on the property would be one example, creating other recreational opportunities, trails, hunting opportunities, spend time listening to all of the family members, and as a forester, be patient, look for those opportunities to talk to landowners about land transfer. So this topic can be complicated. I don't understand it all, and that's why we work with attorneys like Allison Eklund, and we work with CPAs and other folks. I do know that if we don't help landowners plan for the future, that we can, as foresters, expect more fragmentation of private family forest lands. So I think estate or succession planning are two of the most important things that a family forest landowner can do for both the family and to keep the forest intact. And some resources. This presentation will be recorded, so you can go back to this slide, and I'll give you a little bit of time to write this website down. But www.interfacesouth.org, and if you go on that website and look for products, changing roles, and Module 5, there's some things there specifically written to help natural resource professionals talk to landowners about land transfer. Some additional resources. Massachusetts has Your Land, Your Legacy. Again, this website, you'll be able to go back to this website after the presentation. I'll give you about half a minute or so to write some of these down. Estate planning options for family forests is on the www.na.fs.fed.us website. It's also on the timbertax.org website. And then the final one here is When You're So Old. It's a poem that Bob Maley wrote. And he's both a forester and a landowner from Oregon. And it's an inspiring poem to listen to. If you go to this website, it's recorded with Bob Maley actually presenting it. And so I mentioned we will have a workshop on October 24th, and it'll be in St. Paul. It's a 6-hour workshop. To register for that, you can go to the My Minnesota Woods website and find that under the events calendar. And if you want to contact one of the team that makes these presentations, you can contact myself, Becky Hagen-Jokla, or Allison Eklund. And I'm going to go ahead and transition this to the slides for Allison Eklund.
While you're switching slides there, we've got some help. Over in the chat pod, we've got some of the links that Mike just threw up there, including, I just put up the one for My Minnesota Woods. We've also got a shortcut link to the land transfer from Cloquet. And previous to that, we did snag a couple from the longer ones that Mike just put up. So feel free to scroll back up that chat before we switch over to our second presenter for the day. I'll hand it back to you, Mike.
Okay. I'll just quickly introduce Allison. And Allison Eklund's an attorney that we've worked with for a number of years. She's been through the Woodland Advisor classes and has worked with us for probably 8 years on this topic. And so, Allison, I'll turn this over to you.
Okay, great. Thanks so much. It's been a real pleasure to work with the University of Minnesota Extension Forestry Department and with Mike and all our friends here at the U. It's a really great resource available to the public to have all of this educational information about land conservation and estate planning. My presentation is about the legal tools that are available to landowners. In my practice, which is based here just a few blocks away from the University of Minnesota St. Paul campus, I have clients in South Dakota, Wisconsin, and Minnesota, and a law practice in Minnesota, primarily working with people with land and land-based businesses, people with horses, people with cattle, farms, and people with forests, people with cabins. In some cases, it's legacy property that doesn't make money. In other cases, it is, it is a money-making proposition. And some people even have a combination of objectives ranging from gravel pits that make a lot of money for road construction along the interstate highway to purely conservation lands with forests and lakes and streams. And my job is to help people come up with the best solution using legal tools to keep the land in the family and meet the long-term objectives of a landowner. We're going to be talking today about wills, trusts, and business entities and the differences between those tools. For starters, we have to cover the basics. How is land owned? And I think that this is a really important piece because it's hard to talk about keeping land in the family if you don't really have a good grasp of how land is owned in the first place. We talk about land being owned in fee simple, which is a term that dates back to the Old English usage. Fee simple ownership is outright ownership of land. Traditionally, that goes from the center of the earth up into the sky. And most people are familiar with the fact that you can sever some of those rights. For example, you can have mineral rights and surface rights, and those can be divided from one another. The right to own land includes the right to sell it. Even if you have a group of people owning land together, one person can file in court an action called partition, which can request that a court order the sale of land to satisfy a person's financial interest in it. And other aspects of land ownership can include the right to use it for just about anything you want, subject to local law and authority. Restrictions on use or development can be bought and sold through such tools as conservation easements, which is a very useful tool to understand in estate planning. When people own land as individuals but together in a group, the default way to own land is called tenancy in common. In a tenancy in common arrangement, each person independently owns the right to land and it can be inherited by that person's heir. If two people own land as tenants in common and one of them dies, their 50% ownership is inherited by that person's heirs in 20, if they have two heirs, for example, each would inherit 25% of the whole. Now, in joint tenancy with right of survivorship, which is the default only for spouses in Minnesota, joint tenancy with right of survivorship means that if two people own land together and one person dies, then the decedent's interest goes to the survivor, who then owns the whole. Joint tenancy is severable, and in fact I learned fairly recently that a joint tenancy can be severed without knowledge of the other person, except between spouses. Let's say if a brother and a sister own land together as joint tenants, and they assume that if one of them dies, the other person inherits the entire, or receives the entire property. That's not necessarily true if one of them has secretly filed a severance of joint tenancy with the county recorder. So a joint tenancy is not automatic, even if it is titled that way to begin with. It can be severed, and the default ownership is tenants in common. So how is land transferred? What is the mechanical way that land goes from one owner to the next owner? The most common way to transfer land is through a warranty deed. This is what most people understand and sign when they buy a house. There is the title insurance typically involved that ensures the clear title, the good, clean title to the property. And a warranty is the warranty of the seller to the buyer that title is good. And title can also be transferred simply by quitclaim deed. A quitclaim is kind of what it sounds like. It means you're giving up all that you have, but you're not going to guarantee that you had anything to begin with. So a quitclaim deed is a valid surrender of rights to land. And it's basically saying, I wash my hands of this land and I give to you whatever it was I had to begin with, but I'm not going to warranty that it was any particular kind of interest. Land can be transferred by court order. Probate court will issue an order at the end of probate proceedings that will retitle land in the name of the person who inherits it from the decedent. Similarly, a trustee's deed will transfer land from the grantor of the trust to the beneficiaries. So a trustee is the one who supervises and signs a document that affects the transfer of title from the grantor of the trust to the beneficiaries. A district court also can be involved in an action, say in a divorce, where one spouse is awarded property or a portion of property. A district court order also could, as I mentioned earlier, order the forced sale of a property to satisfy an interest in it, and that is called partition. A fairly recent tool in Minnesota is the transfer on death deed. And this is interesting. The transfer on death deed, or the TOD, is a deed that is filed while the person is living but doesn't take effect in the transfer of title until after the person dies. This matters for purposes of, say, tax planning and for chain of title. So if I wanted to make sure that my heirs receive my property, I could sign a transfer on death deed and record it with the county. And if I died, then my heirs would simply have to go to the county and then file the required affidavit and death certificate to effect the completion of transfer of title. That's considered done as of the date that I filed the deed, even though the transfer of ownership takes effect at a later time. A key point about the TOD, or the transfer on death deed, is that it is revocable during the grantor's lifetime. So if I changed my mind, I can go and file a revocation of transfer on death deed, and that is effective as well. So it's a useful tool for someone who believes they know what they want to have happen with their land. It might be the only titled asset that they own. They don't want their assets to have to go through probate court, so they simply file a transfer on death deed so that their heirs will not have to contend with probate. Probate court, how does that work? When people die, any property that was officially titled in their name must be retitled in the names of their heirs. This court process is called probate. If a person dies with a will, then that's called testacy. They died testate. The probate court will follow the instructions in the will to distribute the assets to the beneficiaries. If a person dies without a will, the probate court also will be involved, but will follow state law for intestate succession. And the usual way that that works is that if a person dies, then first you look down to see if the person has any heirs, any children. If they don't, then you look up to see if they have any surviving parents or grandparents. And if they don't, then you look out to the side. Do they have any siblings? Do they have any cousins? And if a person does not have any heirs at law as defined by that state in which the decedent died or has property, then the property can escheat to the state. The state can take possession of a person's property that way. Currently, according to the University of Cornell, which has a wonderful website that you can find federal law and a lot of resources about state laws. According to Cornell, the Uniform Probate Code has been adopted, at least in part, by 18 states, including Minnesota. We do have a Uniform Probate Code. So what happens if a person has property in more than one state? This can end up being a little bit complicated. Each state has exclusive jurisdiction over real estate inside its borders. So the state of Minnesota's courts cannot lawfully transfer title to your cabin in Wisconsin when you die. You have to go to Wisconsin and get what's called an ancillary probate court order transferring title to property in another state. As you can imagine, this can be tedious. It can be time-consuming. It can be expensive. I once had a friend whose mother passed away in Michigan. She had property in Minnesota. She also had timeshares in Mexico and in Florida. And the process of getting all of those retitled was really hard. It was time-consuming. It was more expensive than anyone would have preferred. And it led to some unforeseen consequences, I guess we'll call it. And so how does a person avoid this? You want to have your timeshares, you want to have your Wisconsin woods, you want to have your Minnesota woods, and maybe you've got a condominium in Colorado as well. One way to do that is to have a limited liability company own all of those things. We're going to talk about the nuts and bolts of that very useful tool. A trust can also own property if the goal is simply to make sure that the next generation seamlessly receives title to property. A trust can accomplish the same thing. So these kinds of tools are very useful, especially for people with property in multiple jurisdictions. So what is a trust exactly? A trust is a really neat instrument. Whoever dreamed them up should be praised. A trust is simply a contract that owns property. And it's a contract between the grantor of the trust, the person with property who wants to make sure that it is distributed to the right people when the person dies, and the trustee, who's as the name suggests, somebody that you trust who will supervise the process of retitling assets. The nice thing about a trust is that it can avoid probate, but only if the grantor of the trust remembers to title all their assets in the name of the trust. I've had another acquaintance whose parents died, and my acquaintance said, well, it's no problem, everything's in a revocable trust. So I looked at the instrument, and sure enough, it was a valid revocable trust. But then we looked at all the assets, and nothing was titled in the name of the trust. So the parent had not gone the extra step to make sure that all the bank accounts, all of the assets, the motor vehicles, the land, nothing had been titled in the name of the trust. So a probate court still had to be involved in order to make sure that legally the name goes from the name of the decedent to the name or names of the heirs. A trust is treated as a distinct entity, similar to a limited liability company or a corporation, except that in the case of a revocable trust or a so-called living trust, which is the kind of tool that I most frequently use to help people who want to transfer land to their heirs in a seamless and more immediate sense. A living trust is revocable during the grantor's lifetime. They can change it, they can amend it, they can revoke it altogether, and therefore the IRS, the Department of Revenue, do not consider the transfer or retitling of property into a revocable trust to be a taxable event. And so this flexibility is important. One thing that is important to remember, though, a revocable trust becomes irrevocable when the grantor dies. Now it's a trust, it needs a tax ID number. It is treated as truly a separate entity that owns property and also has to pay taxes. And so if let's say there's an investment account titled in the name of the trust, and if from the date of the death of the decedent to the point that that money is distributed to heirs, there is a substantial increase in the value of those accounts, that increase can be subject to the taxes that are imposed on trusts. And there is typically a higher tax rate imposed on trusts than on limited liability companies, for example, which are pass-through entities, and only the members of the company are taxed as opposed to the company itself. So these kinds of considerations are important, and I'll get into it a little bit with the discussion of limited liability companies as distinct from trusts. The rule against perpetuities. This is an arcane, old English concept, but trusts are subject to it. A trust cannot live forever, just like a person cannot live forever. A trust is limited under a doctrine called the rule against perpetuities, which provides, in non-lawyer speak, that you cannot have a non-vested interest that vests more than 21 years after the death of a person who currently has an interest in the property. It's a little bit arcane and difficult to understand, but the point is that you can't have a trust that lives forever. It's got to vest at some point. Anybody, if anyone has seen, there was a movie about it, the Descendants, about the people in Hawaii who they were looking at the approaching date of the termination of the trust when this property was going to be distributed to the beneficiaries, and they disagreed about whether or not it could be developed or protected from development. That is something that a trust will face. Eventually there will be a date that it has to terminate, and so it cannot live forever. Business entities. Business entities were created, were invented as a legal fiction to own property and conduct business while providing various advantages in taxation to the owners of the businesses. There are, of course, many, many different kinds of business entities. The ones I'm going to focus on are limited liability companies, which under Minnesota law provide a lot of the formality and structure of a corporation with the limited liability protections of a corporation, and the shield from creditors, say, and a separation between the business owners and the conduct of business and the business assets. At the same time, there is a great deal of flexibility in the way that rules and contracts can be written between the investors or the owners, and there is the ability to separate an individual company owner's voting interest from their financial interest, whereas in corporations those are tied together. A corporation is, like a limited liability company, a legal fiction, but a corporation, a so-called C Corp, for example, will pay tax on what it earns. In addition to that, its owners will pay income taxes on what they earn. But a limited liability company is a pass-through tax entity. The owners of the company will pay income taxes on what they earn, but the entity itself does not pay a tax. Instead, it will file, say, a K-1 return, which reports the income of the limited liability company to the IRS, but the income is taxed to the individuals, not to the company itself. So you're only taxed once, not twice. A limited liability company and a corporation potentially can live forever, and this immortality, this potential for immortality, is what makes it a uniquely powerful estate planning instrument, because this limited liability company can be organized and contracts entered into that incorporate the long-term vision for land. And it is this very tool that makes the limited liability company a really wonderful estate planning instrument. So what is a family LLC? A family LLC might be a business. It might expect to make money, but it might not. It might just be a holding company. It does nothing at all except own property. And so it's created, and you have contracts and rules that you've entered into as part of it, but it doesn't have a bank account. It doesn't pay taxes. It doesn't file a tax return. It has no financial existence. It only has a property ownership. And it is a vehicle for contracting among the investors, just as they might enter into a contract for anything, for that matter. The members can adopt rules limiting the eligibility of ownership in the company to the lineal heirs. They can give up the right to partition so that no one person in the company can force the sale of company property. And this is important because the idea is to encourage the peaceable, long-term, durable ownership of legacy property by a group of people who might not always see eye to eye about it. So you're going to set up rules, for example, that might say you have to have either a simple majority vote or a unanimous vote in order to change the rules. Or you might have rules regarding or officially adopting a land stewardship plan, a cabin use plan that sets a calendar and a gatekeeper for keeping the cabin calendar so that everyone has a chance to use it on fair terms. And also there will be what's called a transfer restriction agreement or a buy-sell agreement, which provides very specifically the way in which members of the company can buy and sell or give away interests in the company. The way that these legacy companies can be set up, a member might be able to simply give away their own membership units to their heirs over time and set a very stringent set of requirements for company membership so that it is unlikely to come into ownership by the wrong hands. For example, if a child grows up, gets married, and then divorced, there are waivers of spousal interest that can be required of members before a valid membership will vest. And this can help to make sure that company membership is not attached by creditors and is not subject to bankruptcy attachment. In limited liability companies, we talk about a member control agreement. Effective in 2015, Minnesota's Limited Liability Company Act is going to be changed we recently adopted the revised Uniform Limited Liability Company Act. The member control agreement is going to be called the operating agreement. And it used to be that the bylaws and the member control agreement were separate, but under the new law, they can be merged into a single document. For purposes of today's presentation, I'll continue to call it a member control agreement. It's just a contract. It's a contract among the investors in a company, among the owners of the land who created this company and who gave the land to the company to own. We talked about restricting membership to eligible heirs, presumably lineal descendants of the founders, or maybe it's a larger family than that and you want it to be lineal descendants of grandparents or great-grandparents. It depends, of course, on the definition of family, which can be a very broad concept. The member control agreement can require spouses to sign valid waivers of marital interest. It's important, by the way, if families live in different states to make sure that these waivers comply with the state law where the couple resides. In addition, the contract can discourage buyouts by restricting the value of the land and the company by extension to a percentage of fair market value and set a time period for payment. I think it's important to understand you can't necessarily keep people from requesting to be bought out of a company entirely, but you can make it more attractive for them to stay in the company and cooperate and be a good, productive member of the company than to try and cash out for only a fraction of its actual value. In the case, we have all kinds of stories, as you can imagine, of families that struggle with adult children who become addicted to drugs or alcohol, who might have a mental illness, or who simply just don't get along with their siblings. Garden variety family conflict that can become really difficult to overcome. But these can be addressed by legal tools that set an orderly process for resolving conflict. And so in these member control agreements you can put mandatory arbitration, which is a form of, it's an extracurricular court where you hire your own judge to decide your case, and you can hire an expert in the field of, say, forestry, if it's important to people, or farming or ranching. You can have mandatory mediation, have a third-party mediator who is in charge of mediating conflict before anybody has the right to go to court. You can also have very specific processes for buying and selling, as I mentioned earlier. People often balk at the notion of keeping spouses out of the company. Sometimes this feels heavy-handed. It's sometimes difficult to talk about for some people. So what I explain is that this is not a way of keeping people out of the company. It's a way of involving people in the company without threatening the company and the land's existence. There's a really big difference. Spouses can play very important roles. They can be hired. They can have jobs. They can, people in the family, including spouses, can wear all kinds of official and unofficial hats. You can have cabin coordinators, bookkeepers, and naturalists. And it's wonderful. This is part of the entire goal, of course, is to get families working together and playing together and enjoying property and espousing values that will encourage the survival of this intact property over a long period of time. The purpose of having a spouse sign a waiver of marital interest is simply to make sure that it doesn't fall outside the family in hands that are not competent to vote that interest. And so it is, I like to call it a technicality that is meaningful for the survival of the property and of the company, but that does not affect that spouse's ability to participate in the family, enjoy the property, and take part in the company in all ways except the right to inherit or to vote or to control the company. So what else can a family limited liability company do? It can do just about anything a business can do. It can own life insurance policies to fund potential buyouts. It can buy health insurance, long-term care insurance. It can set up benefit plans for members, buy, sell, and lease other properties. You might have property, as I mentioned earlier, in many different states. One property might receive income, Airbnb, VRBO, and some of these rental sites. The income from one property might help pay the property taxes on another property. Companies can establish their own social networking presence. My parents have a property where we've set up a private Facebook page, and we can share photographs of the refrigerator contents to make sure that we don't have to bring up another bottle of ketchup. There are many, many aspects to the coordination possibilities, the legal contractual possibilities, and the more elegant financial solutions as well. These things can be used to, they can't be used necessarily to avoid estate taxes, but they can mitigate the impact of estate taxes through the gradual transferring of membership interests to heirs. So it's important always, of course, to talk to a CPA or to your tax planner about your plans for your property if it might have an impact or invoke the estate tax either at the federal or state level. But there are tools for mitigating the impact of the estate tax as well. So if you're considering a company, on the pro side, it can avoid probate of land and possibility of partition by contract agreement. It creates a legacy of land stewardship principles if you adopt, say, a land stewardship plan. It encourages the peaceful co-ownership among heirs through cooperative agreements. And it can be organized to minimize the estate tax burden. On the downside, there is an extra cost of retaining an attorney. There might be disagreement. It might be difficult to come to any agreement about what to do with the property, about whether or not there is an interest in preserving this as legacy property or wanting to cash out. So the heavy lifting really is done at the family level before any of this can be fully actualized. There might be difficulty funding expected buyouts. It is not uncommon for families to have a diversity of income generating potential among heirs, and in that case the question becomes, what about the one sibling who doesn't have enough money really to participate in upkeep of the cabin? You know, if there's going to be $10,000 required of the owners for a new roof, but only one person realistically has the money to pay for it, then, you know, how do you structure ownership so that everybody can enjoy it, but the person who's going to be funding most of it might have a disproportionate interest? This can be, but the beauty of an LLC is that you can account for those differences. If only one person really realistically has the financial ability to support this property, then defining their ability to use it is something that can be customized to the family and to the feeling of fairness among the members. Paperwork and formalities. Yes, there is some formality to this. The member control agreement, the operating agreement, bylaws, articles. The articles are filed with the Secretary of State. It is a business entity that is recognized by law. There are going to be some terms. There are going to be some requirements like annual meetings, minutes, resolutions, approvals, paperwork that connects the dots to show that this company exists and is following rules. But they're not as onerous as they might sound. It really is not as big a deal as some people fear. And I encourage people to find an attorney, talk to an attorney who can explain and walk you through the entire process of setting up and managing these companies in a way that makes it much more understandable and accessible to families acting as families and not as sterile corporate entities, because they are not. And that's really, again, the beauty of an LLC. If you can find an attorney who will sit down and work with you and customize these agreements, is that you can have this company behave like the family that it is, and it doesn't have to be as sterile and formal as the paperwork might suggest. Land preservation can be accomplished through a lot of different tools, but ultimately family integration is one of the most important pieces to address in the transfer of private land interests where there's a significant preservation value over the long term. My name is Allison Eklund. I'm an attorney, and I specialize in estate planning for landowners. You may certainly call me. I'm happy to talk to people. I do not charge for consultations, and I'd be more than happy to accept your referrals or to talk to you about any question that you may have. Thanks.
All right, thanks, Allison. I've asked a couple times for questions from online. We don't have any at this time, but maybe people are considering it right now. So we'll pause for a minute or two. And if you have questions for either Allison or Mike, use the chat box on the left side of the screen to type that in.
That's it. Hopefully we get some questions, and if not, the presentation will be posted. I'll be around.
Yep, we just had the link posted on the side for requesting CE credits from a personal computer. So if you're one of those who have joined us from your house or your office, use that link to claim your continuing education credits. Okay, so we've got another message in here. Oh yes, please, if you have feedback for how today's webinar went, take a couple minutes to go to the link z.umn.edu/2014 feedback and let us know how we did today. Still waiting on that. And as I wait for a first question, actually I have a question for Allison. I noticed that some of the bullets you listed for Family LLC, our family does, just kind of informally for our cabin. What is I would imagine for our family it is the formal steps that's the biggest hurdle to get towards that ownership of that cabin under something like this. Is that pretty common, that some of these things are already happening informally and a formal process is not that far away from the way things work?
I think so, yes. I mean, families are as diverse as the imagination can go. So for families that are already functional and have a process in place, ours does too. We have 5 adult kids and the 2 owners of the property, the parents, and we call my mom the gatekeeper. Nobody can arrange to stay at the cabin property without first going through the gatekeeper, the keeper of the calendar. There are rules about making sure the refrigerator is emptied of leftovers and making sure that we don't have any more mouse problem than we already have. And all of these pieces are, they're subject to family informal agreements. But they can be written down, or they can simply be incorporated by reference in some of these formal agreements. You might have a very informal but written agreement and just say in your member control agreement, you know, the Smith family cabin reservation plan is adopted and incorporated by reference, as it may be changed from time to time. and that does it. You know, same with the land stewardship plan. There are people who already have forested lands enrolled in the Sustainable Forest Incentive Act, for example, which requires a land stewardship plan that's approved. And that can be incorporated by reference. This is a way to simply say, we've made the rules in our company, and we want to also recognize that we've already gone through this process in a whole separate sense. We have use rules, we have land stewardship plans, and you might also say, you know, that nobody in this company may ever have the authority unilaterally to change those approved plans without the company's approval. You know, so all of this is an important piece. It just is really making more formal and enforceable the rules that already exist in some cases.
Okay, we've got a few questions percolating now that we've kind of taken it all in. Okay, there's already one in the chat pod from our leader in Cloquet. In your experience, Allison, from a longer-term conservation standpoint, is a conservation easement approach or a family LLC approach more effective at maintaining the natural integrity of the property?
Well, that's a really good question. When land stays in the family, it's important to understand that at any time the entire family could unanimously decide to sell the property, change the agreement, change the rules. Anything can be done unanimously. But a conservation easement is different. A conservation easement is the decision now to give away or sell a part of the land that you simply will not own anymore. So once you give away or sell the development rights to the land, you don't have that anymore. So you can't, by unanimous agreement, decide we want that back. As long as there is an organization and an enforcement mechanism out there to make sure that that activity that was the right to which was given away never happens, it really is a permanent solution. But nothing can, nobody can tell the future. So say conservation easement is a wonderful tool for somebody who absolutely wants to make sure that this can never be developed. But on the other hand, they could just say, well, I'm going to put this property in my will and make sure that I give the entire property to the Minnesota Land Trust, or to a nonprofit that I created that I know is going to live forever and will always have my values. Well, there are many different ways to try and say forever, but in the end, human beings don't live forever, and human beings from one generation to the next do change. Laws change, governments change. So as much as we know how, I think the conservation easement is a fairly permanent solution that takes place immediately, where you are giving away the right to develop the land, and that settles the matter. The only way to get it back is to talk to the entity that you gave it to and say, I think we want to renegotiate, which is not supposed to be possible. But then again, I think that keeping property within private ownership, although some people might think that's not a great idea, it's the realistic probability for most families that consider land to be a tremendous asset. So this is a compromise approach, essentially, to say, yes, this is really valuable land. We want it to be in the family. We want everybody to be able to enjoy and use it. We don't want to put any legal restrictions on its use immediately that would last forever. But we want to pass on to the next generation and to future generations an ethic, an appreciation for conservation, our values, our understanding of what's important about this land. And that's where the agreements and contracts can be useful in this kind of arrangement.
Okay, great, thank you. Ernest from the Minnesota DNR would like to know, foresters working with their clients may be asked about approximate costs to set up a family. I'm sorry, that's not his question, but it's a different question from Cloquet. Foresters working with their clients may be asked about approximate costs to set up family LLC. How should they respond?
It's across the board. Attorneys charge sometimes by the hour. They might charge a flat fee. I have a typical price that I would charge would be $1,500 for the creation of an entity, or say a pair of wills or a pair of trusts. From start to finish. Sometimes it involves trusts and a company. Sometimes it involves, and if you have a trust, you also have the pour-over wills. So different attorneys will structure that differently. I know that my brother paid a large law firm downtown Minneapolis $4,500 just to do a pair of wills, so I would consider that to be the upper end of what things might cost. On the other hand, I know of some attorneys who just charge $750 for a pair of wills. So as you can see, it really runs the gamut. It's very variable. The most important thing, though, is to find somebody who is competent, who understands the tools, and who's not going to give something that's out of a can. Anybody who's an attorney can go to the Bar Association and get the suggested format materials for estate planning and wills and trusts. I mean, the canned solution is readily available to just about any attorney. The real trick here is finding somebody who can talk to families, who can deal with the complexity of issues that arise, who can be creative in understanding the tools and their applicability to individual situations. And it's worth paying money for people with that kind of experience. So it's really a process of vetting and making sure that you feel comfortable with the person's professionalism, and hopefully finding something that also meets your budget.
For those of you who have been trying to claim that continuing education credit, we had a slight typo in it. There was no period at the end. The replacement link is now up in the chat. Okay, now to Ernest's question. Thanks for your patience. Allison, you mentioned that gradual transfer of ownership can mitigate inheritance tax. How is this affected if the owners are infirmed in a nursing home, for example, and they're liquidating assets?
Mm-hmm. This is a huge issue, and I could probably spend another half day talking about issues of competency and conservatorship and guardianship when it comes to ownership of property. Without getting into that whole area, because it's hard, as you can imagine. I mean, how can a person even sign a contract if their mental competence is at issue? Ideally, we would have people set up these kinds of arrangements while they're still young and vital and can share their land ethic with the next generation. Prevention, what do you say, an ounce of prevention is worth a pound of cure. So one really great thing about a limited liability company, if it's set up properly, is that it can be a really great way to shield the property from creditors. It cannot necessarily survive the look-back period if somebody goes into a nursing home and the state subsidizes that and comes looking for assets. The state has a way of reaching people's assets no matter what in order to satisfy debts for long-term care or nursing home care and so forth. But aside from that look-back period and some vulnerabilities that would need to be addressed on that level, depending on the individual situation, I think that a limited liability company is a pretty good solution for most people.
Okay, and we have one more question. So if you've been holding back, and now is the time, we're coming up right at 1 o'clock. So Lynette would like to know, how does a forest stewardship plan fit into an LLC?
It's adopted. The people put in the member control agreement that we have a land stewardship plan, and we hereby incorporate it by reference. And it can be an entirely separate document, which is usually what I recommend, I think, because the land stewardship has a whole separate language. I mean, legal documents, I hate to say it, they are written with some legalese, and there are reasons for it. It's because judges speak that language, and you want the person enforcing your rights to speak the same language as the tools that you're using. So we have these documents, we have to use some of that kind of language, but what we do is we incorporate by reference these separate contracts and agreements and a land stewardship plan and say this is forevermore a part of our company, it's a part of our member control agreement.
Okay, we do have one final question from the group in Rochester. What's a look-back period and how long is it?
I believe it is 5 years, and it's a period during which if a person say, well, let's take an extreme situation. A person realizes that they've got a debilitating disease, and they want to make sure that, and they realize that they're going to have to go into a nursing home. They can't afford to fund the nursing home. They're going to go, and they want it to be state funded. So they start dumping their assets, and they give away the house to the kids, they give away the cabin to the grandkids, they start transferring giving away all their property. Well, the state can go back and nullify those gifts, and in some cases can even undo the transfer of property into a limited liability company if the state can prove that this was done in a way that fits the statute. I'm not, this has been tinkered with, so I'm not going to make any representations about the circumstances under which the state will do that. I've had some experience dealing with the state where I was shocked they didn't. So that's a ticklish issue, and I don't want to make any representations that could come back to bite. But yes, there is a look-back period. I believe it's 5 years during which the state can say, we're going to undo some transfers of your property if we think that property should have been used to satisfy your debt to the state to pay for your care.
Okay, I think we've exhausted the questions. The only other comments coming in are that we want to get that continuing education link to work, and so we're going to spend another 2 to 5 minutes on that. It is a little bit after 1 o'clock, so thank you to Allison and Mike for presenting today. I'll pause for a little bit, but please stick around online if you need that continuing education link. I will be working with someone with our link shortener to make sure that that's working. It could be that our referral is just not bouncing correctly. So thank you.
Thank you.